Hello, and thank you for joining me for the third part of our IP talk on digital health, in which I'll be providing some practical advice on identifying and patenting digital health inventions. My name is Jack Severs. I'm a UK and European patent attorney at Gill Jennings Every. GJ are a specialist IP law firm with our main office here in London, and we advise a wide range of clients across patents, trademarks, and design rights. I lead GJ's MedTech Business Development Group, and so a significant part of my time is spent advising health tech companies at various stages. And the aim for this talk is to provide some practical advice which reflects the questions that arise most often around patent protection of digital health technology. So in the first two parts of this talk, we looked at how to consider whether your digital health technology is patentable. In the final part, we'll look at considerations in determining whether patent protection is the right option. So during the live version of this talk, we received the question, are patents necessarily needed to break into healthcare? The short answer is no. Patent protection will be important for a large number of companies in health tech, but certainly not all of them, as I will show. So ultimately, it comes down to the fact that you need to assess the value that patent protection will bring to your business and for your specific technology. So in order to assess whether patent protection is the right option, we need to consider the benefits of patent protection to digital health companies. You're likely aware of the main overarching value of patent protection is that it adds up to a 20-year monopoly in which you control use of your invention. So more specifically, you can stop any third party from making, selling, or using a technology that falls within the scope of your patent. Clearly, if you've developed a commercially valuable technology and you obtain strong, broad patent protection for that, that puts you in a very strong position in the market. It means that you can stop any competitors from entering the market, which is very attractive to investors. Clearly, if you've developed a new technology which they're interested in and you're the only one that can use it, then that makes you a very attractive investment target. It can also provide a new revenue stream because you can license out your technology to a third party under conditions of your choosing in return for licensing fees. It can assist with commercial and licensing negotiations. And like any other property that has a value, the company that owns a valuable patent will have an increased valuation. It also provides marketing weight. So if you're positioning your company as at the cutting edge of a particular technology, then clearly holding a number of patents backs up that claim to your customers and to other companies that you do business with. Finally, there's tax breaks associated with products covered by a UK patent, so you can get a reduction in corporation tax. So there's clearly a lot of value in patent protection, but what about alternative options? So one particular possibility, which is relevant to certain types of digital health companies, is whether you could instead keep aspects of your invention confidential. So this is particularly relevant for software-based inventions where the new features are part of the back end and won't be released when the product is released onto the market. So one important consideration for the patent process is that it's an agreement. So in return for obtaining a monopoly for your particular technology, in return, you need to describe how the invention works in your patent application so that others can build on your technology. That's the agreement at the heart of the patent process, which is intended to stimulate innovation. So a patent application is published after 18 months. So any details that you include in the patent application will be made public. So clearly, if these relate to parts of the invention which might not otherwise have been disclosed, you need to consider whether that's the right option. A related point is if it is impossible for a third party to determine aspects of your algorithm, your new algorithm, because it's fully at the back end of your product, would you ever be able to determine whether a competitor was using your patented technology? If you've developed a new specific algorithm for diagnosis, for example, which is based on a server at the back end, would you ever be able to tell that a competitor was using the same algorithm for you as you in order to enforce your patent? Clearly, as we've seen, one of the benefits of patent protection is being able to stop competitors from using your technology. But in order to do so, you need to make a clear case that that competitor is infringing. So if you can't do that, then that's one of the benefits of patent protection, which is reduced. So to return to the third example from the second part of my talk, which related to a smartphone app, including an algorithm for image processing for a skin cancer diagnosis. So this company, this fictional company, has developed a new smartphone app that uses the camera to obtain a picture of the skin. They've developed a new machine learning classifier algorithm for classifying image data to provide a risk indication. And they've developed a new approach to training that machine learning model to learn data representations of that image data, which are particularly effective for classifying images taken with a smartphone and for determining a change over time in those images. So here, if all the new features are simply part of the algorithm and are hidden at the back end, so maybe you take a picture with your camera, it's sent off to the server where it's processed by your new model. Should you keep those new features confidential rather than filing a patent application in which they will be disclosed after 18 months when the patent application is published? So there are a lot of considerations here, and I'll go through them one by one. The first two relate to whether those features would be obvious when the product's released. So this means that they may not necessarily be explicitly disclosed, so clear features like the fact that you need to take a picture on your camera, which is clear when the product is released, when using the product. But would you ever be able to infer whether a competitor is using those claimed features in order to be able to enforce the patent? So for example, are there features to do with how the data is actually submitted, which are linked to the algorithm features? And so if a competitor was using those similar features for data submission, could you infer that they were using similar or the same algorithm features as you? The next point relates to how broadly or narrowly will you have to claim and describe the invention in your patent application? Clearly, if you think you're able to get a broad claim which protects the system as a whole, so protects broadly a smartphone configured to take a picture, process the image in order to provide an indication of skin cancer diagnosis, then at that broad definition, it's quite clear if a competitor is using a similar product or has developed a similar product and has put it out on the market. However, if what you're going to get granted only relates to very specific features of the algorithm, it's going to become increasingly more difficult to determine whether a competitor is using those features in their product. So an important consideration is how broadly or narrow you will actually be able to obtain patent protection. And of course, on the far end of that spectrum is, will you be able to obtain patent protection at all? So if you're applying for a patent for something which is very unlikely to be considered technical, for example, you might have to weigh up the fact that, well, it looks very unlikely that I'm going to get a patent granted, and filing the patent application will eventually mean that these features are published. You would then think that perhaps the better option would be to keep it confidential. I should say that the way the Patent Office works is that you receive a report on the patent application prior to it being published. So you can always file a patent application, review the Patent Office's search report to determine how likely you are to obtain broad protection, and then make a decision about whether to proceed with the patent application or not. Another important issue is how important do you think a patent is to secure funding or to support licensing negotiations or to support your marketing efforts? So you need to come up with how much value you think those kind of issues are in filing for a patent. Finally, a question that I've seen come up more often recently is I've seen a number of companies who are operating really at the cutting edge of a particular technology, and part of their business, part of their approach is to publish their results on the successes of their algorithm. So if you intend to publish details of your algorithm in any case and publish your results, then clearly it doesn't matter if those features are also going to be published in your patent application. So in those situations, the companies have opted to go ahead with patent protection because at least it then provides a deterrent to competitors who might read your publications, for example, in journals, and try to implement your technology. So returning to the example, in this case, the algorithm features relate to taking multiple pictures over a defined time period. And of course, that means that the way of inputting those pictures is you have to take a sequence of pictures over that time period. So although the new features relate to the algorithm, they can be inferred by actual use of the product. And so that suggests that patent protection would be of greater value if you can infer that a competitor is using similar features in their algorithm. Again, in this situation, we're saying it looks from the search report that broad protection is possible. You may even be able to keep some specific details out of the patent application in the first place. And the obtaining a patent is particularly important for investment and for licensing. So therefore, we've come to the conclusion that patent protection is likely the right option. But this just illustrates that you really have to weigh up those considerations for these kind of technologies where the new features relate to the back end, so particularly for software related digital health inventions. So to summarize, is patent protection the right option? Well, firstly, if your invention relates to parts of the technology which are clearly visible or can be inferred when the product is released, so particularly if they're hardware features, device features, then patent protection is very likely the right option, because if those features are easily copied by a third party, then you want to have protection in place. Secondly, if the invention relates to back-end features which need not necessarily be disclosed, then you really need to weigh up the considerations that I've set out and come to a conclusion about whether the value of obtaining a patent outweighs the fact that some of those features will be disclosed in your patent application. So clearly, patents are an important part of an IP strategy for digital health companies, but they're not the full picture. There are other relevant types of IP rights, and we particularly discussed a number of examples of the application of machine learning in digital health inventions. And there are a lot of further issues wrapped up in that which we haven't discussed today, particularly around data, whether you have the correct contractual rights to process patient data, and whether those rights allow you to own new IP developed based on that data. So for that reason, we decided to do a second talk on digital health in which we'll look at AI, data, and the wider IP considerations. So I'd suggest that you look for that on our YouTube channel, particularly if those aspects around machine learning are relevant to your digital health technology. So that concludes the third and final section of this talk on patenting digital health inventions. You can find the first two parts on our YouTube channel. If you'd like to find out more about IP and how to protect your innovation more generally, then there's lots of information available on our website, gjE.com. If you have any specific queries, then please do feel free to email me at jack.severs@gje.com, or you can connect with me on LinkedIn, and I'd be happy to answer any specific questions that you have. Thanks very much for listening.